I was unable to give you subsequent classes. My sincere apologies for the same. For our last class, we were dealing with nationality, citizenship. So I believe I have already spoken about how a person acquires nationality and loses its nationality. And I was intending to move on to the concept of statelessness. Okay, so let me show my slide to you. Wait a minute, just wait. I hope everyone can see. കാണാൻ പറ്റുന്നുണ്ടോ?
Yes, sir.
Okay, 1 minute. Okay, I will make it a full screen. So these are the slides I have prepared, and we have gone through distinction between citizenship and nationality. Okay, now basically what I have mentioned is the citizenship and nationality are used synonymously, but there is a difference. Okay, now citizenship is the internal status of a person in relation to a country. Okay, so citizenship shows according to the municipal law to which country you belongs to. Okay, where citizenship is a relationship between an individual and a state.
Sandeepന്റെ picture ആണ് visible ആയിട്ടുള്ളത് അതോ slide visible ആണോ?
Can everyone else can see the slide? എല്ലാവർക്കും കാണാൻ പറ്റുന്നുണ്ടോ?
Slide visible ആണ് sir.
Okay, right.
Sabi sir, ഇത് എന്റെ സ്ലൈഡ് സബിസാറിന് കാണാൻ പറ്റുന്ന കോളങ്ങളിൽ ഒരു കോളത്തിലായിരിക്കും എന്റെ സ്ലൈഡ് ഇരിക്കുന്നത്. അത് ചിലപ്പോൾ പിങ്ക് വരുന്ന കേട്ടോ.
ഞാൻ എക്സിറ്റ് ചെയ്തിട്ട് വീണ്ടും എൻട്രി അപ്പൊ കറക്റ്റ്.
Okay, fine. So citizenship is the status of a person within the territory of a country. Basically, ഒരു രാജ്യത്തിനുള്ളിൽ ഒരാളുടെ relationship with that country is known as citizenship. Okay. Now, nationality is the relationship of a country, of an individual with a foreign territory. Okay, so nationality comes into significance when a person is in a foreign territory. Imagine I who's a person who's a citizen of India. Okay, that is my relationship with the Indian territory. That me as an individual within that Indian territory, I have the relationship of citizenship with India. Okay, so when I go abroad in any foreign territory for that US or UK or any other country, in relation to that foreign territory and myself, that relationship is indicated by nationality. So I am an Indian national living in America or the United Arab Emirates. Okay, non-residential Indians and NRIs according to the municipal law of India, It is otherwise known as non-residential Indians, NRIs. So that is the difference between nationality and citizenship. Okay, citizenship is the relationship between an individual with and the territory to which he belongs. Okay, legally he belongs. That is citizenship. Nationality is when that individual is in a foreign territory. Nationality comes into play. So, what and who can decide nationality? I have already mentioned. Nationality is decided by the culmination of international law as well as municipal law. Okay, municipal law decides to which nationality a particular person will belong to. Okay, that I have already discussed. So I am moving very fast. Yeah, I believe that in the last class, I have already discussed certain international documents which calls for granting of nationality or citizenship to individuals. That is, we UDHR pertinent provisions നമ്മൾ നോക്കി, then Convention on Nationality of Married Women നോക്കി. So there are different international conventions that says that every individual has the right to be a citizen or a national of a country. Okay, that is very important. When an individual has to operate within the territory of any country. Okay, nationality gives you, or citizenship gives you a bundle of rights. That is the reason. Nationality is, or citizenship is not only a relationship between an individual and a country. That a relationship grants that particular individual certain rights and obligations, and those rights and obligations are very essential when it comes to realizing the fundamental rights of that individual. Okay, അപ്പം നമ്മള് കഴിഞ്ഞ ക്ലാസ്സിൽ we have gone through a series of international conventions which calls for granting of citizenship to each and every individual. Okay, now moving on, other than those conventions we have already discussed, ഞാൻ ഈ കൺവെൻഷനിൽ ഒന്നും കൂടി പോകേണ്ട ആവശ്യമില്ലല്ലോ. I believe that when you read each and every provisions that I have mentioned in the slide, I believe I have already shared the slide. നിങ്ങൾക്ക് കിട്ടിയിട്ടില്ലെങ്കിൽ I will again try to share it with you. But there are a series of regional and international conventions that says that no person shall be denied his right to citizenship or nationality. Okay, now acquisition of nationality. How does a person acquire nationality? So I have already mentioned, I believe this is already mentioned. By birth on the state territory, just soil എന്ന് പറയും. That is, you have to give the citizenship of a person is decided by in which territory that particular person is born. Okay, now അടുത്തത് എന്ന് പറഞ്ഞാൽ just soli is a Latin word and its translation is right to soil. Okay, then by descent from a state's national, that is being born to the parents of a particular nationality, you can also acquire nationality. Otherwise, in other words, you acquire the nationality of your parents, either of your parents, and that is known as just sanguinis. In other words, right to bloodline. Okay, just sanguine, it is translated as right to bloodline, or other words, you acquire nationality or citizenship through the bloodline of your parents. Okay, now another concept is by naturalization. Okay, naturalization is a process where citizenship is granted to you by a foreign state. Okay, and that can happen by getting married to a foreigner. Okay, by getting married to a foreigner, you can acquire the citizenship of that foreigner. When anyone adopts a child, the child who is adopted acquires the citizenship of the person who is adopting that particular child. And the last one is by acquiring domicile. Domicile, in other words, it's by acquiring residence in a particular country, usually for a period of 12 years. If a person acquires residence in a foreign country, he has the right to get naturalized. Naturalized means you apply for the citizenship of a foreign country based on these scenarios. Okay. And you will get naturalized. Another way in which you get naturalized, which I have not mentioned here, is if you make any contributions. If you make any artistic, political contribution to that particular country, you can also get naturalized. Okay. Now there are a lot of musicians, Pakistani musicians, artists who are born in Pakistan who have acquired Indian citizenship. That is because under Indian Citizenship Act, if you have contributed culturally to India in terms of arts and music, due to that contribution that you have made to the country, you have the right to acquire citizenship. That is naturalization. Okay. Then by resumption, there is another method by resumption that I believe I have not mentioned in the last class. By resumption, it means you try to resume your past citizenship after acquiring a foreign citizenship. Okay, there are many Indians who have acquired foreign citizenship, and many of them do come back to India and resume their citizenship. And this resumption can be gained by usually by residing within India for a significant period of time, or by making an application for resumption. Okay, under Indian Citizenship Act, an Indian or a person of Indian origin can make an application to resume his or her citizenship. Okay, that is resumption. That is, you are resuming your past citizenship or nationality that you have relinquished. Okay. Now by subjugation, there is another method of acquiring nationality or citizenship, and that is by subjugation. Okay. Subjugation here means imagine the case of Crimea. Crimea situation or imagine the case of Ukraine. Okay, I believe all of you know the war that is happening between Ukraine and Russia. I hope I don't have to explain. There is a war that is happening between Ukraine and Russia, and Russia is invading Ukraine in the name of denazification and the democratization of Ukraine. Okay. Basically, denazification is Russia excuse. So here, if Russian invasion of Ukraine succeeds, and Russia decides to incorporate the Ukrainian territory into Russia, okay, after winning the war, you are basically subjugating a foreign country. Okay, once you have subjugated a foreign country by war and incorporated its territory, the country the citizens of that country who are subjugated by war, they acquire the citizenship. They may acquire the citizenship of the country who was victorious. Okay, who has subjugated. Okay, so basically, if Russia subjugates Ukraine and incorporates Ukrainian territory into Russia, the people who the citizens of Ukraine may acquire Russian citizenship. Okay, that is acquisition of nationality by subjugation. Now, next one is by secession. Okay, secession means a country peacefully joins the territory of another country. Okay, that is secession. Okay, if you take the Indian history, the history of independent India, subsequent to Indian independence, after the coming into force of the Indian Constitution, there were many princely states who remained undecided whether to join Pakistan or India. Okay, so many princely states who were sovereign nations by themselves decided to join the Indian Union, and one of those states were one of the most popular, famous states were the state of Travancore. Okay, that is there in Kerala. So the state of Travancore decided to join the Indian Union by peaceful means. Okay, so if any country tries to join the territory of another country or try to become part of the territory of another country, it is known as succession. Okay, so when the princely state of Travancore joined the Indian Union, the nationals or citizens of Travancore acquired the Indian citizenship or Indian nationality. Okay, that is succession. Succession is also happening. There is another classical example, that is the European Union. So there is European Union is a very special case. I think it will not be mentioned in the syllabus. It is not directly mentioned in the syllabus, but keep this in mind. The European Union is a transnational organization, and when a country joins the European Union, it acquires the citizens of that country who has joined the European Union acquires the Schengen visa, acquires the European citizenship. Okay, citizenship of the European Union through the Schengen Treaty. Okay, there is another terminology known as the Schengen visa. European Union is a classical example. When you join the European Union, you become a citizen of the European Union. Okay, that is succession. So these are the main modes by which you acquire nationality. Now, these are the certain provisions that I have mentioned where you acquire citizenship by birth. One of the famous countries who has a legislation that recognizes citizenship by birth is United States. I have mentioned the provision. There is also a provision within the British Nationality Act and the Indian Citizenship Act. If you go into the Indian Citizenship Act section 3, it is there. Now I have given the legal provision for each of the modes through which nationality can be acquired. Okay, so kindly go through those provisions. I will not be mentioning them here. Now coming on to loss of nationality. Okay, you are losing your nationality. Now kindly pay attention to this. There are mainly there are different ways to lose citizenship, and what I have mentioned here are the main five main methods or modes through which a person may lose nationality. Okay, now the first mode is by release. What do you mean by release? Okay, by release is a mode of losing nationality where a person applies to the country to be released from the nationality or citizenship of that country, particular country. Okay, so you are making a application. Okay, you have a nationality or a citizenship, and as an individual you are making an application to your country that kindly release me from this nationality or citizenship. Okay, that is an application of release. So this particular method of losing nationality is provided under many of the communist countries. Okay, in many of the communist in many countries who declare themselves as a communist country, they have this mode of losing nationality. That is the mode of by release. You take Cuba, you take China, you take the Soviet Union, you take North Korea. All these in all these countries, you have to make an application of release. Okay, you have to make an application, and this application has to be approved by the country. Okay, when you make this application saying that you need to release this, you need to get relieved from the citizenship or nationality in order to pursue your business or profession, in a foreign country, if you give the reasons and the reasons are approved by that particular country, you can relinquish your country and relinquish your nationality or citizenship, and you will be permitted to travel into that foreign country. Okay. So in very authoritative nations, authoritative undemocratic countries, the majority of the people will be trying to flee from that territory. Okay, in order to prevent that people from fleeing the territory, there are such measures similar to the application for release. Okay, so you have to make an application for release from North Korea, so that the North Korean government can allow you to travel to a foreign country and reside there. If you don't make this application and try to escape from that country into a foreign country, it is known as defection. Okay, you are defecting. This happens in this happened in the Soviet Union, and also this is also happening in North Korea. Because of the authoritarianism, because of the economic depredation, people try to leave this communist countries to another foreign country, and when they do this, it is not without making this application of release. When they do this, it is known as defection. Okay, you are defecting from that country to another country. Okay, now another one is by deprivation. You lose your nationality by deprivation. Now, deprivation is where a country decides to withdraw or eliminate or terminate the nationality or citizenship of an individual. Okay, when does that happen? We have seen that many foreigners from different parts of the world has gone to Iraq and Syria to fight, to join the ISIS. Okay, that is the Islamic State of Iraq and Syria, ISIS, in order to join the ISIS forces and to fight for that organization. Many foreigners from around the world has joined that group, and those who have joined this group, their nationality has been cancelled or terminated by their respective countries. Okay, we have an example in Kerala. Many Indian citizens who are born in Kerala, they have gone to Syria and Iraq, and they are prohibited from coming back to India. The same goes for many UK, US citizens whose citizenship has been cancelled or terminated. Okay, this is because they have violated the law of a particular country. Okay, they have acted against the national security or national interest of a particular country. In those circumstances, each and every state has the authority to withdraw or to terminate the nationality or citizenship of that individual, concerned individual. Okay, so deprivation happens usually in the contemporary world. Loss of nationality by deprivation happens when you join terrorist organizations. Okay. Now another method by which you lose nationality is by renunciation. You're renouncing your nationality. Okay, so renunciation, when you compare between loss of nationality by release and loss of nationality by renunciation, there is a similarity. Okay, in both these situations, the individual is making a decision. That an individual is making a conscious decision to surrender his nationality or citizenship. Okay, but the difference between the two is that renunciation happens by implication. Okay, in loss of nationality by release, you are making an express statement that you want to surrender the nationality of Soviet Union, the nationality of North Korea, the nationality of Cuba. You are making an express declaration in the method of release. In renunciation, you are making an implied indication that you want to surrender your nationality. That is surrender of your nationality by implication, by actions and omissions. Okay, by actions and omissions, you are surrendering your nationality in the method of renunciation. So what happens in renunciation is that in the municipal law of many countries, there is a provision that a country can only have one citizenship. Okay, you cannot have more than one citizenship. Okay, and in these countries, under those legislations, you are acquiring a foreign citizenship. Okay, you are acquiring a citizenship by any of the method of acquiring nationality I have mentioned earlier. Okay, by naturalization, you are acquiring citizenship by naturalization or by residence of a foreign country. You automatically will lose the nationality of your birthplace. Okay, nationality of your origin. Okay, India is a classical example. According a citizen can only have one citizenship, and if any Indians acquire any foreign citizenship by naturalization or by residence, that particular Indian citizen who have subsequently acquired the foreign citizenship, they are technically renunciating Indian citizenship. Okay, they are making a renunciation by acquiring a foreign citizenship, because under Indian law you cannot have both. You can only opt for either Indian citizenship or a foreign citizenship. By going into a foreign citizen, by acquiring a foreign citizenship, through implication, you are surrendering your Indian citizenship. That is renunciation. Okay. Then losing nationality, you can also lose your nationality by residing in a foreign country. Okay. Then there is another method, that is substitution. By substitution, you can lose nationality by substitution. Here you can under the laws of many countries, you can interchange. Okay, you technically you can decide. For example, you in Norway and Israel, between these countries, under the laws of these countries, you can change from Israeli citizenship to Norwegian citizenship, and at any time you can decide to change again from Norwegian citizenship to Israeli citizenship. Okay, so you can substitute between two countries according to your convenience. Okay, so there are municipal laws in and around the world which permits this type of substitution of nationality and citizenship. Okay, so you can also lose nationality by substitution. Okay, because this is a very difficult concept to understand. In the previous class, I have taken up to acquisition of nationality, how you acquire nationality. I hope you have understood the laws of nationality. Anyone? Any doubt? If you have any doubt, I can answer them. I hope all of you have understood this one. By release and renunciation and Tamil or similarity on, but the main difference is release is an expressed statement that I have surrendered my nationality and citizenship. Renunciation is an implied statement. Okay. Substitution substitution is you can interchange your nationality. Israeli citizenship Upon an Indian citizenship Israel Indian citizenship Indian citizenship opt. Okay, application fill. I hope everyone understood. Reply I cannot see the screen, unfortunately. Can anyone say whether you have understood or not? ഞാൻ audible ആണല്ലോ അല്ലേ?
Yes, sir. Yes, sir.
Yes, sir.
Okay, can we move on to the next one?
Excuse me, sir.
Hello?
Sir, there is a doubt, sir. What is the difference between deprivation and renunciation?
Deprivation and renunciation. Deprivation and renunciation. ആരാ സംശയം ചോദിക്കുന്നത്? പേരെന്താ പറയാമോ? ആരാ ചോദിച്ചേ?
Sir, ആ ചാറ്റ് ബോക്സിലാണ് സുബർ നായർ.
Okay, Suparna Nair. Okay, fine. Difference between deprivation and renunciation. Okay, deprivation എന്താണ് സംഭവിക്കുന്നത് എന്ന് പറഞ്ഞാൽ it is the country or the nation state that decides to terminate nationality or citizenship of an individual. Okay, whether to terminate the nationality or citizenship of an individual is decided by the country in deprivation. Okay, it is the state which is depriving the individual of the nationality or citizenship. അതേസമയം renunciation എടുക്കുകയാണെങ്കിൽ എന്താ സംഭവിക്കുന്നത്? The decision to surrender or terminate nationality or citizenship is not made by the state, rather it is made by the individual. Okay, by actions or omissions. Individuals in the action or omission വെച്ചിട്ട് individual he or she is deciding to surrender their citizenship. Okay, renunciation എന്താ സംഭവിക്കുന്നത്? വേറൊരു foreign countryയുടെ citizenship acquire ചെയ്യുന്നു, either by naturalization or by residence. You are acquiring the foreign citizenship of a foreign country. At the same time, the country of your origin, the municipal law of the country of origin is saying that you can only acquire one citizenship at a time. അങ്ങനെ ഒരു നിയമമാണ് ഉണ്ടെങ്കിൽ അവിടെ ഉണ്ടെങ്കിൽ എന്താ സംഭവിക്കുന്നത്? ഓട്ടോമാറ്റിക് ആയിട്ട് ബൈ ഇംപ്ലിക്കേഷൻ യു ആർ ലൂസിങ് ദി സിറ്റിസൺഷിപ്പ് ഓഫ് ദാറ്റ് country of origin while you are acquiring foreign citizenship. Okay, the difference between the two is that who is making the decision. In deprivation, the decision is made by the state. In renunciation, the individual is making the decision. Okay, that is the main difference. മനസ്സിലായോ?
Sir, it's clear. മനസ്സിലായി.
Okay, ചെറിയ confusion വരാൻ chance ഉണ്ട് between those, but try to understand. Okay, then let me move on. അപ്പം അടുത്ത ചോദ്യം എന്താണെന്ന് വെച്ചാൽ, ആൾക്കാർക്ക് സിറ്റിസൺഷിപ്പ് നഷ്ടപ്പെട്ടു കഴിഞ്ഞാൽ അതായത് the next question that we need to answer is there a possibility that once a person loses his nationality or citizenship, or once a person has surrendered his nationality or citizenship, is there a possibility that that particular person may not get a new citizenship or a citizenship of a foreign country? അങ്ങനെ ഒരു സാഹചര്യം ഉണ്ടോ? ഒരാൾക്ക് അയാളുടെ അല്ലെങ്കിൽ അയാളുടെ സ്വന്തം നാഷണാലിറ്റിയോ സിറ്റിസൺഷിപ്പോ നഷ്ടപ്പെട്ടു പോയാൽ, അല്ലെങ്കിൽ അയാള് ആ സിറ്റിസൺഷിപ്പോ നാഷണാലിറ്റിയോ സറണ്ടർ ചെയ്യാൻ തീരുമാനിച്ചു കഴിഞ്ഞാൽ, ആ സറണ്ടർ ചെയ്ത സമയത്തും നഷ്ടപ്പെട്ട സമയത്തും ആ വ്യക്തിക്ക് ഒരു ഫോറിൻ കൺട്രിയുടെ സിറ്റിസൺഷിപ്പ് കിട്ടാതിരിക്കാൻ ചാൻസ് ഉണ്ടോ എന്നാണ് അടുത്ത ചോദ്യം. Chance ഉണ്ട്. Okay, there is a chance. Okay, there is a chance that a person once he loses his citizenship or nationality, he may or may not get a new citizenship from a foreign country. Okay, when a person does not acquire the citizenship of a foreign country, or when a person does not belong to any country, okay, when a person does not belong to the citizenship or nationality of any country, such a situation is known as statelessness. Okay, അപ്പൊ സ്റ്റേറ്റ്ലെസ്നെസ് എന്ന് പറഞ്ഞാൽ ഒരു സിറ്റിസൺഷിപ്പ് നാഷണാലിറ്റി ഇല്ലാത്ത ഒരു അവസ്ഥയാണ് സ്റ്റേറ്റ്ലെസ്നെസ്. ഇറ്റ് ഇസ് എ സിറ്റുവേഷൻ ദാറ്റ് ഇസ് ഫേസ്ഡ് ബൈ ആൻ ഇൻഡിവിജ്വൽ at the international level. Okay, so statelessness can happen by release, by deprivation, by renunciation, by residing abroad, by substitution. ഈ പറയുന്ന ഡിഫറെന്റ് മോഡ്സ് ഓഫ് ലൂസിങ് നാഷണാലിറ്റി, ഞാൻ നമ്മൾ നേരത്തെ സംസാരിച്ച ഡിഫറെന്റ് മോഡ്സ് ഓഫ് ലൂസിങ് നാഷണാലിറ്റി, ആ മോഡുകൾ വരുന്ന സിറ്റുവേഷനിൽ ദർ ഇസ് എ പോസിബിലിറ്റി ദാറ്റ് എ പേഴ്സൺ മേ ബിക്കം സ്റ്റേറ്റ്ലെസ്. ഒരു ചെറിയൊരു എക്സാമ്പിൾ ഞാൻ ഇവിടെ പറയാം. ദാറ്റ് ഈസ് ഇൻ ദ കേസ് ഓഫ് സ്റ്റോക്ക് വേഴ്സസ് പബ്ലിക് ട്രസ്റ്റി എന്ന് പറയുന്ന ഒരു കേസുണ്ട്. സ്റ്റോക്ക് വേഴ്സസ് പബ്ലിക് ട്രസ്റ്റി. ഓക്കെ, പബ്ലിc trustee before Justice Russell of the Chancellery Court 1920. അതായത് ഈ ഒന്നാം ലോക മഹായുദ്ധം അവസാനിച്ചത് 1919. In 1919, the First World War ended. Okay, and there was a peace treaty that was signed between the victorious states and the states who lost the war. Okay. But it was in the accord between Germany and the Allied forces. They decided to acquire the property of properties belonging to their citizens. Okay, Germany citizens അല്ലെങ്കിൽ നാഷണൽസിന്റെ പ്രോപ്പർട്ടി അക്വയർ ചെയ്യാനുള്ള ഒരു എഗ്രിമെന്റ് they have signed. Okay, so that is the Allied forces who became victorious. They can acquire the property of German nationals within their territory. Okay, for example, UK territory-ക്ക് ഉള്ളിൽ ഏതെങ്കിലും ജർമ്മൻ നാഷണലിന്റെ പ്രോപ്പർട്ടി ഉണ്ടെങ്കിൽ യുദ്ധത്തിന് ഉണ്ടായ നഷ്ടങ്ങൾ റിക്കവർ ചെയ്യാൻ വേണ്ടിയിട്ട് in order to realize war reparation എന്നാണ് പറയുന്നത്. അതായത് ജർമ്മനി ആയിട്ട് ഒന്നാം ലോക മഹായുദ്ധം നടത്തിയതിന് UK-ക്ക് ഉണ്ടായ നഷ്ടങ്ങൾ നികത്തുവാൻ വേണ്ടിയിട്ട് ജർമ്മനിയുടെ സിറ്റിസൻസിന്റെ പ്രോപ്പർട്ടി UK-യിലുള്ള പ്രോപ്പർട്ടി അറ്റാച്ച് ചെയ്യാനും ലിക്വിഡേറ്റ് ചെയ്യാനുള്ള അധികാരം ആ പീസ് അക്കോർഡിൽ വഴി ജർമ്മനി UK-ക്ക് കൊടുത്തിട്ടുണ്ട്. I am giving you an example. The same power has been given to each and every allied country. Okay, those who became victorious. That includes Japan, America, Canada. ഈ പറയുന്ന രാജ്യങ്ങളിലെല്ലാം അവർക്കെല്ലാവർക്കും ജർമ്മൻ നാഷണൽസിന്റെ പ്രോപ്പർട്ടി അറ്റാച്ച് ചെയ്ത് ലിക്വിഡേറ്റ് ചെയ്ത് അവർക്കുണ്ടായ നഷ്ടങ്ങൾ നികത്തുവാൻ പറ്റും. ദാറ്റ് ഈസ് ദ ബേസിക് ഐഡിയ. പക്ഷെ ഇവിടെ സ്റ്റോക്ക് എന്ന് പറയുന്ന ഒരു ഇൻഡിവിജ്വൽ, he claims that he is not a German national. Okay, according to him, he claims that he is a British citizen. അയാള് ഒരു ബ്രിട്ടീഷ് സിറ്റിസൺ ആണെന്നാണ് പുള്ളിക്കാരൻ ക്ലെയിം ചെയ്യുന്നത്. He is not a German citizen. Okay, basically he was born in Prussia. Okay, he acquired the citizenship of Prussia by birth. Okay, that is just solely or right to soil. Using the doctrine of right to soil, he was born in Prussia, which was later acquired by Germany prior to which was part of the German territory. Okay, so he had the German citizenship by birth, but he consciously made a decision to reside in United Kingdom. Okay, he resided in United Kingdom for 13 years. 13 വർഷം കണ്ടിന്യൂസ് ആയിട്ട് റിസൈഡ് ചെയ്തു. ബട്ട് subsequently he was deported to Holland. Okay, and after being deported to Holland for committing a crime, this Holland was conquered by Germany, and the argument made by the defendant was that when Holland was conquered by Germany, all the persons who were within the territory of Holland acquired German citizenship. Okay, so therefore Stock belonged to Germany. He had the German citizenship or German nationality. അതുകൊണ്ട് the property, the Stock's property that was there in UK, that he made a lot of investment in limited liability company. Okay, കുറെ പ്രൈവറ്റ് കമ്പനികളുടെ ഷെയർസ് ഈ സ്റ്റോക്ക് എന്ന് പറയുന്ന ആള് ഹോൾഡ് ചെയ്തായിരുന്നു. Okay, shares of many UK companies were held by Stock. Even while residing in Holland, he had many properties located in UK. So when the war between UK and Germany broke out, he was declared an alien enemy, and as he was interpreted as it was assumed by the government that he had German nationality. The argument made by Stoke is that he had British citizenship. He did not have German citizenship. I spoke about another case that was there in parallel to this one. That is the case of I forgot that case, the title of the case. Nevertheless, this is a fact. Okay. Stoke പറയുന്നത് he is a UK citizen, and the British government does not have the right to acquire or liquidate his property, and he is not an alien enemy. That is the argument made by him, because he acquired British citizenship by continuously residing in Britain, and he had the intention to acquire British citizenship even before the outbreak of war. Okay. The arguments made by Stoke was accepted by the court, and all the properties that was attached by the British government was returned to him along with compensation. Okay, this is the case. This case, Justice Russell പറഞ്ഞത് എന്താണെന്ന് വെച്ചാൽ, if a person is not a citizen of any state, he will be called as a stateless person. Okay. The terminology or concept was defined in this particular judgment. And further, it was held that the question to which state a person belongs must be answered by interpreting the municipal law of the land to which the person is being alleged or claimed to have belonged to. Okay. In other words, the British government must establish the fact according to the German law. Stoke is a German citizen, and Stoke must establish that he is a British citizen by relying on the British legislation. Okay, so the citizenship or nationality of a particular person is decided by the municipal law of that country. Okay, not by any international convention, but the municipal law of the country to which he claims to be a citizen, or it is alleged to be a citizen. Okay, for municipal law we have to take into account. That is what it was held in Stoke versus Public Trustee before the Chancellery Court. Okay, this is a very important judgment in UK. Now, another one that is very important is the Hague Convention. Hague Convention of 1930. So, the convention on certain questions relating to conflict of nationality laws. That is the formal title of this convention. In short, it is known as Hague Convention 1930. The formal title is Convention on Certain Questions Relating to Conflict of Nationality Law. So during this time in 1930s, during the First World War and prior to the First World War, nationality was decided by private international law, not by public international law. Okay, prior to the Hague Convention of 1930, the citizenship of a particular country is decided by private international law or conflict of law. Ellarkum private international law endanennu njan assume cheyunu. I hope everyone understands what is private international law or conflict of law. Ariyamo aarkengilum? Can anyone say or define what is private international law or conflict of law? Anyone? Anyone cares to define it? Private international law ennu paranjal, if a foreign element is involved in a particular case, a foreign element if a foreign element is involved in a particular case before a domestic court, that court has to decide which law shall be applied. foreign element in the foreign law apply cheyano ado whether the court should apply the domestic law ennulla question undu. Okay, foreign element ennu paranjal in the case of marriage between a foreigner and an Indian national, there is a foreign element. In a question relating to property belonging to a foreigner in India, there is a foreign element. Okay, so whenever a foreigner is involved in any manner, in any fashion, in a legal dispute within a country, within the legal framework of a country, under any court in a country, a foreign element involved avunna dispute ഏത് നിയമം വെച്ച് ഡിസൈഡ് ചെയ്യണമെന്നുള്ള ക്വസ്റ്റ്യൻ വരും. ഓക്കെ, സോ conflict of law or private international law is the law which contains the principles which helps the court, okay, which aids the court before whom the foreign element has appeared to decide which law to apply. Okay, which law between the foreign law and the national law, which law shall be applied to decide that particular case. Appa ഏത് നിയമമാണ് അപ്ലൈ ചെയ്യേണ്ടതെന്ന് ഡിസൈഡ് ചെയ്ത് കഴിഞ്ഞാൽ അവിടെ പ്രൈവറ്റ് ഇന്റർനാഷണൽ ലോയുടെ റോള് തീരും. Okay, the private international law is basically used to decide which law, whether the national law or the foreign law should be applied to decide a particular case involving a foreign element. That is private international law. So private international law, for a long time it was the private international law that decided whether a particular individual belongs to this nationality or that nationality, or that citizenship or this citizenship. Okay, it was the private international law that decided whether a particular individual is an Indian citizen or a foreign citizen. Okay, prior to the Hague Convention 1930. So ningalku ellarkum ariyam, those who studied private international law, it is very difficult to decide which foreign law to apply, because private international law is ultimately different customary practices of different countries. It takes a lot of time to determine the appropriate customary law to decide a particular case. So in order to avoid all this confusion that is brought in by private international law, many of the principles of private international law has started to be codified into international law. Adinu oru classical example aanu event settled model law. Event settled model law is a codification of private international law in relation to arbitration. Okay, arbitration ആയിട്ട് കണക്ട് ചെയ്ത് ഇന്റർനാഷണൽ ആർബിട്രേഷനുമായിട്ട് കണക്ട് ചെയ്തിരിക്കുന്ന പ്രൈവറ്റ് ഇന്റർനാഷണൽ ലോയുടെ ഒരു കോഡിഫിക്കേഷൻ ആണ് ഇവന്റ് സെറ്റിൽഡ് മോഡൽ ലോ. അതുപോലെ ഈ നാഷണാലിറ്റിയും സിറ്റിസൺഷിപ്പും ഡിസൈഡ് ചെയ്യാൻ ഉപയോഗിക്കുന്ന പ്രൈവറ്റ് ഇന്റർനാഷണൽ ലോയുടെ പ്രിൻസിപ്പിൾസ് എല്ലാം കോഡിഫൈ ചെയ്യുന്ന ഒരു ഇന്റർനാഷണൽ കൺവെൻഷൻ ആണ് ദ ഹേഗ് കൺവെൻഷൻ ഓഫ് 1930. Okay, that you have to understand. Kindly try to understand that private international law is increasingly becoming codified into international conventions under public international law, in order to avoid the confusion and the delay in deciding the appropriate principle to decide a particular case. Appam ee oru Hague Convention 1930 or convention on certain questions relating to conflict of international law, Article 2 ningal nokkanengil, if you look into Article 2, you will see that whether a person possesses the nationality of a particular state shall be decided by the municipal law of that state. Okay, adana Hague Convention പറയുന്നത്. So Hague Convention again recognizes and acknowledges that the nationality or citizenship of a particular person should be decided by the municipal law of that country. If a person is claiming that he is an American citizen, his citizenship shall be decided by the American law. If a person is claiming that he is an Indian citizen, his citizenship or nationality shall be decided by the Indian law. That is the principle behind Article 2, and this is originating from private international law. Okay, now ഇതിനെ കുറിച്ച് ഈ സ്റ്റേറ്റ്ലെസ്നെസ്സിനെ കുറിച്ച് ഓപ്പൺഹൈമറിന്റെ പബ്ലിക് ഇന്റർനാഷണൽ ലോ എന്ന് പറയുന്ന ബുക്കിനകത്ത്, പ്രിൻസിപ്പിൾസ് ഓഫ് പബ്ലിക് ഇന്റർനാഷണൽ ലോ എന്ന് പറയുന്ന പുള്ളിക്കാരന്റെ ബുക്കിനകത്ത് പുള്ളിക്കാരൻ പറഞ്ഞിരിക്കുന്നത് എന്താണെന്ന് വെച്ചാൽ, stateless persons are like ships which are floating in the open sea without a flag. Okay. ഇതെന്താണെന്ന് വെച്ചാല് ലോ ഓഫ് ദ സീ എന്ന് പറയുന്ന, നിങ്ങൾ LLB-യിൽ നിങ്ങൾ എല്ലാവരും പഠിച്ചു കാണണം. ലോ ഓഫ് ദ സീ എന്ന് പറയുന്ന ഒരു ഇന്റർനാഷണൽ കൺവെൻഷൻ, ദാറ്റ് ഈസ് ഇന്റർനാഷണൽ ലോ that governs transaction on and under the sea, the law of the sea. അവിടെ യുണൈറ്റഡ് നേഷൻസ് കൺവെൻഷൻ ഓൺ ലോ ഓഫ് ദ സീ 1986 ഉണ്ട്. അപ്പം അതിനകത്ത് ആ കൺവെൻഷൻ അനുസരിച്ച് ഓരോ ഷിപ്പുകളും, ഓരോ കടലിലൂടെ പോകുന്ന ഓരോ ഷിപ്പും ആ ഷിപ്പിന്റെ രജിസ്റ്റർ ചെയ്ത രാജ്യത്തിന്റെ ഫ്ലാഗ് ഹോയിസ്റ്റ് ചെയ്യണമെന്നുണ്ട്. ഓക്കെ. Every ship has to be registered, every ship on the open sea has to be registered to a particular country, like a registration number of a vehicle. നമ്മളിപ്പം നമ്മുടെ റോഡിൽ ഒരു വണ്ടി ഇറക്കണമെങ്കിൽ we have to get a number plate, registered number plate, അല്ലെ? The number plate of a particular vehicle indicates which the vehicle belongs to which district. ഏത് ഡിസ്ട്രിക്ട്, ഏത് സ്റ്റേറ്റ്, ആ സ്റ്റേറ്റിന്റെ ഏത് ഡിസ്ട്രിക്റ്റിലാണ് അത് ബിലോങ് ചെയ്യുന്നതെന്നാണ് ആ നമ്പർ പ്ലേറ്റ് ഇൻഡിക്കേറ്റ് ചെയ്യുന്നത്. അതുപോലെ തന്നെ കടലുകളിലെ ഓരോ ഷിപ്പിലും ഒരു രജിസ്ട്രേഷൻ നമ്പർ ഉണ്ട്. ആ നമ്പറിന്റെ കൂടെ തന്നെ ആ ഷിപ്പ് രജിസ്റ്റർ ചെയ്തിരിക്കുന്ന രാജ്യത്തിന്റെ ഫ്ലാഗും കൂടി വെക്കണം. അപ്പൊ ആ ഷിപ്പിലെ ആൾക്കാരെ ഗവൺ ചെയ്യുന്ന നിയമം ആ ഷിപ്പിന്റെ ഫ്ലാഗിന്റെ നിയമങ്ങളായിരിക്കും. അതായത് ഫ്ലാഗ് സ്റ്റേറ്റിന്റെ നിയമങ്ങളായിരിക്കും. ഓക്കെ. അപ്പം ഓപ്പൺഹൈമർ he's trying to say that stateless persons are like ships floating in the open sea without a flag. ഇപ്പൊ ഫ്ലാഗ് ഇല്ലാത്ത ഒരു ഷിപ്പ് ആണെങ്കിൽ the ship it is not governed by any law of any country. That particular ship does not have any rights or obligations. അതുപോലെയാണെന്നാണ് ഓപ്പൺഹൈമർ പറയുന്നത്. And that is very deplorable situation according to him. Okay, so that is there. Then Convention on Reduction of Statelessness 1961. അപ്പം ലോസ് ഓഫ് നാഷണാലിറ്റി കാരണം ഓരോ വ്യക്തികൾ അവരുടെ നാഷണാലിറ്റിയും സിറ്റിസൺഷിപ്പും നഷ്ടപ്പെടുമ്പോൾ അവർക്ക് അവകാശങ്ങൾ ഇല്ലാതാവുകയാണ്. ഡ്യൂട്ടീസും ഇല്ല, റൈറ്റ്സും ഇല്ല. റൈറ്റ്സും അതായത് the fundamental rights of an individual has to be protected and promoted by a country. Okay, whether it is America, whether it is India, whether it is China, whether it is North Korea, whether it is Russia, ഈ എല്ലാ രാജ്യങ്ങളുടെ കോൺസ്റ്റിറ്റ്യൂഷൻ അകത്തും അവര് ഡെമോക്രാറ്റിക് ആണോ അൺഡെമോക്രാറ്റിക് ആണോ എന്ന് നമ്മൾ നോക്കണ്ട. Regardless of the type of governance, whether it is undemocratic or democratic, if you look into each and every constitution of every country, the constitution of every country around the world promises certain fundamental rights to the citizens of their country. Okay, ആ ഫണ്ടമെന്റൽ റൈറ്റ്സ് എന്ന് പറഞ്ഞാൽ ഇന്ത്യൻ കോൺസ്റ്റിറ്റ്യൂഷനിലെ ഫണ്ടമെന്റൽ റൈറ്റ്സ് തന്നെയാണ് എല്ലാ രാജ്യങ്ങളുടെ കോൺസ്റ്റിറ്റ്യൂഷനിലെ ഫണ്ടമെന്റൽ റൈറ്റ്സ് പ്രോമിസ് ചെയ്യുന്നത്. അപ്പം ഒരാൾക്ക് ആ സിറ്റിസൺഷിപ്പോ നാഷണാലിറ്റി ഇല്ല എങ്കിൽ ആ പറയുന്ന ഫണ്ടമെന്റൽ റൈറ്റ്സ് അവർക്ക് വേണ്ടിയിട്ട് പ്രൊട്ടക്ട് ചെയ്യാൻ വേണ്ടിയിട്ട് ഒരു രാജ്യം ഇല്ലാതാവുകയാണ്. ബേസിക്കലി അവർക്ക് ഫണ്ടമെന്റൽ റൈറ്റ്സ് ഇല്ലാതാവുകയാണ് ഈ those who become stateless persons. And very recently in the contemporary world, ഒരു മാസ് പോപ്പുലേഷൻ, ഒരു എത്നിക് ഗ്രൂപ്പിന് സ്വന്തം നാഷണാലിറ്റി നഷ്ടപ്പെട്ടിട്ടുണ്ട്. റോഹിംഗ്യ മുസ്ലിംസ് എന്നാണ് അവരെ പറയുന്നത്. റോഹിംഗ്യ മുസ്ലിംസ്. ഈ റോഹിംഗ്യ എന്ന് പറയുന്നത് they are native ethnic people who traces their origin from Burma. ബർമയിലെ എത്നിക്കലി ഡിഫറെന്റ് ആയിട്ടുള്ള ഒരു ഗ്രൂപ്പ് ഓഫ് കമ്മ്യൂണിറ്റിയാണ് റോഹിംഗ്യാസ്. അവര് അക്സെപ്റ്റ് ചെയ്തിരിക്കുന്ന റിലിജൻ എന്ന് പറഞ്ഞാൽ ഇസ്ലാമാണ്. ഇസ്ലാമിക് റിലിജൻ ആണ് അവർ അക്സെപ്റ്റ് ചെയ്തിരിക്കുന്നത്. And the Rohingyas are ethnically different from the majority population of Burma. അവര് മംഗ്ലോയിഡ് ആണ്. Majority population of Burma is Mongoloid, and the ethnic population of Rohingyas are somewhat similar to the people who belong to Bangladesh. Okay, ഈ ബംഗ്ലാദേശിലെ ആൾക്കാരെ പോലെ ഇരിക്കും ഈ റോഹിംഗ്യ മുസ്ലിംസ്. And the argument made by the Burmese state is that the Rohingyas are the people who emigrated from Bangladesh to Burma, and they are not the actual citizens of Burma, as they are ethnically and religiously different from the Burmese. Okay, so the state of Burma or Myanmar, the government of Myanmar denied citizenship or nationality of Burma to the ethnic groups of Rohingya Muslims, and there were many atrocities that were committed against the Rohingya Muslims by the majority Mongoloid Burmese population, and that is well documented by the United Nations Human Rights Council. What happened is many countries are unwilling to give citizenship to Rohingya Muslims. Majority of the Rohingya Muslims are in Bangladesh. Cox's Bazar, they are camped in a location that is called as Cox's Bazar. Very recently, there was a fire that happened in the refugee camp in Cox's Bazar, and many people died. Majority of the Rohingya Muslims are in Bangladesh. Many others have fled to Australia, New Zealand, which is very near to Burma. The Australian government and the New Zealand government has refused to grant citizenship to many Rohingya Muslims. As a matter of fact, what they have done is they deported the Rohingya Muslims to Bangladesh. Bangladesh is currently they are accepting Rohingya Muslims from Burma, but the Bangladesh government is not granting them any citizenship or nationality. Okay, so they currently they are the latest group of ethnic minorities who have recently lost nationality or citizenship. And there are many others. During the Syrian civil war, during the war that was happening in Iraq and Syria between ISIS and other opposition forces, there was an ethnic group known as the you see, there are two ethnic groups. There were many ethnic minority groups in Syria and Iraq, who does not belong to the Islamic religion. Okay, who does not belong to the religion of Islam. They are ethnic minorities, and they were being prosecuted by the ISIS forces as well as the opposition forces. And they have technically they lost. They don't have any nationality or citizenship. Okay, they have become refugees. Okay, these stateless persons, all of them have become refugees. The situation of stateless persons are much worse than refugees. Okay, because all stateless persons are refugees, but not all refugees are stateless persons. Okay. You can become a refugee with your nationality intact. Okay, for example, the Ukrainian citizens. Okay, even though Russia is invading Ukraine and many people are fleeing Ukraine to many other European countries, technically they are refugees, but they have not lost their Ukrainian citizenship or nationality. Okay, so but the situation of stateless persons are much worse. And this is, again, it is a deplorable condition that has to be rectified. And with this intention, the international community has come up with the Convention on Reduction of Statelessness in 1961. So the discussion for Convention on Reduction of Statelessness was happening from 1954 onwards, because after the Second World War, the Second World War commenced in 1936. And it ended in 1954. Okay, when the Second World War ended in 1954, the borders of many countries were redefined. Okay, many countries lost territory, many countries acquired territory, and in this chaos, again, many minority groups were discriminated against. Especially in Europe, like the Jewish population. Okay, during the Second World War, many Jews had to flee the European continent to escape from Nazi Germany, and many of them became stateless. They could not go back because their country has been acquired by Soviet Union, or it has been acquired by many of the allied forces. For many of them, their country has ceased to exist. Okay, many countries ceased to exist. Many new countries came into existence. And during this chaos, many people became stateless, especially the Jewish population. There was a huge number of people who became stateless after the conclusion of Second World War. Okay, that is what war does to you. Whenever there is a conflict, there is a possibility that many people will become stateless. So I should have mentioned this in the mode of losing nationality, but under international law, it is not expressly recognized. But war is also a reason for losing nationality or becoming statelessness. Okay, which is not expressly acknowledged by international law. അപ്പോൾ ഈ കൺവെൻഷന്റെ സാലിയന്റ് പ്രൊവിഷൻസ് കുറച്ച് ഇമ്പോർട്ടൻറ്റ് പ്രൊവിഷൻസ് ആണ് ഞാൻ ഇവിടെ മെൻഷൻ ചെയ്തിരിക്കുന്നത്. That will shed light on the objective of the convention. Okay, if you look into Article 1 of the convention, it is trying to say that a contracting state means a state which is party to this convention. A contracting state shall grant its nationality to a person born in the territory who would otherwise be stateless by birth or operation of law. Okay, if any person is born within its territory, okay, India is not a party to this convention on reduction of statelessness. Okay, India is not party to any of the refugee conventions, including the convention on reduction of statelessness. Many developing countries are not party. Many developing countries like India is not party to this refugee conventions. There are a series of refugee conventions, including the Convention on Reduction of Statelessness 1961. The reason why India has opted out of this convention is because if you become a party to this convention, it may cause a lot of economic burden on you. Okay, lot of economic, social, and political burden on the developing countries. So many of the developing countries have opted out of this convention. At the same time, many of the countries who are party to this convention are developed nations. Okay, so under this convention, if any person is born in Belgium, for example, or in Norway, if any person is born in Norway, imagine a Rohingya Muslim. Okay, a Rohingya Muslim who has fled to Australia is born in two parents of a child. Okay, imagine two parents who have fled to Australia to escape the Burmese government. They have given birth to a child in Australia. Okay, if Australia is a party to the Convention on Reduction of Statelessness, Australian government has to give citizenship to that child who is born in the territory of Australia. Okay, because if Australia does not grant citizenship to that child will become stateless. Okay, so by giving citizenship to that child, you are reducing the possibility for statelessness. Okay, that is mentioned in Article 1. If you read further into Article 1, it also says that you should also give citizenship to that parents. Okay, then that child acquires citizenship of your country, or automatically the citizenship will also be acquired by the parents of that child. Okay, in that way you can reduce the possibility of statelessness. That is mentioned in Article 1. If you go into the another provision, that is Article 1 clause 3. A child born in wedlock in the territory of a contracting state whose mother has the naturality of that state shall acquire the birth of that nationality if it otherwise would be stateless. Okay, ഇവിടെ എന്താ പറയുന്നതെന്ന് പറഞ്ഞാൽ if a child who is born in the territory of a state has a mother who belongs to the nationality of that state, the child will acquire the nationality of that mother if the child becomes stateless otherwise. Okay. Usually under international customary law, the nationality of a child who is born in the territory of a foreign country is decided by the nationality of the father. Okay. That is the usual customary practice. The nationality of a child is decided by the father of the child. Pashe, there is a situation that a child is born in the territory of a country of a contracting state, and his mother has the nationality of that country, and his father is a stateless person. Okay, here who is a stateless person? The stateless person is the father. There is a stateless person, and the father is a stateless person, but the mother who is married to him is a national of that country. Okay, therefore, if any child is born, that child will acquire the nationality of the mother. അതായത് ഒരു റോഹിംഗ്യ മുസ്ലിമിനെ ഏതെങ്കിലും ഒരു ന്യൂസിലാൻഡിലെ ഏതെങ്കിലും ഒരു ലേഡി കല്യാണം കഴിക്കുകയാണ്, അവർക്ക് ഒരു കുഞ്ഞുണ്ടാവുകയാണെങ്കിൽ ആ കുഞ്ഞിന് ന്യൂസിലാൻഡിലെ ഓസ്ട്രേലിയയിലെ സിറ്റിസൺഷിപ്പ് കൊടുക്കും. ഓക്കെ, ദാറ്റ് ഈസ് ദ സ്പിരിറ്റ് ഓഫ് ആർട്ടിക്കിൾ 1 ക്ലോസ് 3. അടുത്തത് എന്താണെന്ന് വെച്ചാൽ, എ കോൺട്രാക്ടിംഗ് സ്റ്റേറ്റ് ഷാൽ ഗ്രാന്റ് ഇറ്റ്സ് നാഷണാലിറ്റി ടു എ പേഴ്സൺ നോട്ട് ബോൺ ഇൻ ദ ടെറിട്ടറി ഓഫ് ദാറ്റ് കോൺട്രാക്ടിംഗ് സ്റ്റേറ്റ് who would otherwise be stateless if the nationality of one of his parents at the time of the person's birth was that of the state. That's Article 4. If you go into Article 4, there is a person who is born outside the territory of the state. പക്ഷേ ആളുടെ പേരൻസിൽ ആരെങ്കിലും ഒരാള് ഈ കോൺട്രാക്ടിംഗ് സ്റ്റേറ്റിന്റെ നാഷണൽ ആണെങ്കിൽ that person will acquire the citizenship of that particular country. Imagine ഒരു റോഹിംഗ്യ മുസ്ലിമും ഒരു അമേരിക്കൻ സിറ്റിസനും തമ്മിൽ കല്യാണം കഴിക്കുകയാണ്, and a child is born to them in India. Okay, a child is born to them in India. That child will acquire American citizenship because one of the parents are American citizens. Okay, avade angane the possibility for statelessness angane koranjittundu. I am giving you an example. Again, you look into another provision. If the law of the contracting state entails the loss of nationality as a consequence of any change in personal status of a person, such as marriage, termination of marriage, legitimation, recognition, or adoption, such laws shall be conditional upon possession of acquiring of another nationality. ഇവിടെ എന്താ പറയുന്നതെന്ന് പറഞ്ഞാൽ, ഒരാളുടെ മാരിറ്റൽ സ്റ്റാറ്റസിന്റെ ചേഞ്ചസ് കാരണം. ഓക്കെ, ഇമാജിൻ ഒരു അമേരിക്കൻ സിറ്റിസൺ ഹാസ് മാരീഡ് എ റോഹിംഗ്യ മുസ്ലിം. They married in Burma and they have settled in Burma. Okay, when the American citizen married a Burmese, when an American citizen married a Rohingya Muslim in Burma and they settled in Burma, the American citizen will acquire Burmese citizenship. Okay, under international customary law. But as I have discussed, there is a persecution of Rohingya Muslims in Burma, and both the American former American citizen and their other partner, that is the Rohingya Muslim partner, tried to escape to America. Avade endha sambhavikkunnennu paranjal, their child will if any child is born to them, they will acquire American citizenship. And the American citizenship will be restored. Okay, to the former American citizen, the American citizenship will be restored. the spouse and the child will be acquiring American citizenship. അതാണ് ഈ പറയുന്ന ആർട്ടിക്കിൾ 5 ക്ലോസ് 1 പറയുന്നത്. ഓക്കെ, സോ ബൈ മാരിറ്റൽ സ്റ്റാറ്റസ് അല്ലെങ്കിൽ ബൈ ചേഞ്ച് ഇൻ പേഴ്സണൽ സ്റ്റാറ്റസ്, അതായത് ഒരാളുടെ റിലിജൻ മാറ്റുകയാണെന്ന് വിചാരിച്ചു. In many countries, changing your religion is a criminal offense. Due to the reason that you have changed your religion, you have lost your nationality and you are unable to acquire any foreign country. You have become stateless by changing your personal status. You can also change your personal status other than by marriage. You can change your personal status by changing your religion. If you change your religion in many countries, it is a criminal offense and you cannot go back to that country. The punishment for that criminal offense will be death penalty. Okay, so in that way you may become stateless. Under those situations also, a contracting state can grant citizenship, okay, in order to avoid statelessness. I think you understood the spirit of Convention on Reduction of Statelessness, right? So basically the Convention on Reduction of Statelessness is trying to reduce the possibility of statelessness as far as possible. If you read into any of the provisions, it is focusing on individuals. The child who is born to a stateless person, a stateless person who is born outside the territory of a contracting state, a stateless person who is born within the territory of a state contracting state, a stateless person who is married to a citizen of a contracting state. By taking into all these variables, the convention is trying to reduce the possibility of statelessness, because statelessness is a huge violation of basic human rights under international law. അത് റെഡ്യൂസ് ചെയ്യാനാണ് ഈ കൺവെൻഷൻ ഉദ്ദേശിക്കുന്നത്. So there are around 20 articles in the Convention on Reduction of Statelessness. Unfortunately, you have to go through all of these articles. But even though if you don't go through all these articles, you kindly ensure that the provisions that I have mentioned in the slide you check, okay, and verify. So I will conclude my class here, and we will resume from next class. In the next class, I will be talking about asylum. Okay, asylum under refugee law. We will be talking about refugees and how asylum is granted to refugees. Okay, in the next class. Okay, if there is any questions, you may ask. If there are no other questions, we will conclude the class.
Participants, please kindly come forward if you have any queries.
Again, my apologies, everyone, for the delay in completing the class. എനിക്ക് frequent ആയിട്ട് ക്ലാസ്സുകൾ കണ്ടക്ട് ചെയ്യാൻ പറ്റിയില്ല. My deepest apologies. If there are no questions, I think we can wind up.
Okay, sir. Thank you, sir, for your wonderful session. Thank you, sir.
Thank you, everyone. Take care. Good night.